There's been a lot of attention recently on the decision of Ms Chandler and Westpac in relation to making requests and responding to requests for flexible work arrangements. In this case, the applicant, Ms Chandler, had been employed by Westpac since 2002, and she had worked from home for an extended period of time. Her employer, Westpac, had recently implemented a hybrid working policy which required attendance at a corporate office 2 days per week. In January this year, Ms Chandler made a request for flexible working arrangements so she could work from home all of the time, or at least have the requirement to attend a corporate office 2 days per week reduced. Crucially, she'd done so in writing. She'd been employed for a period of 12 months, and she also had responsibility for looking after children, getting them to and from school, and thereby had complied with all of the requirements under the National Employment Standards when making that request. The Fair Work Commission found that Chandler's caring responsibilities were significant and genuine, and that it found its request was reasonable in the context of her role and in the context of the Fair Work Act. The Fair Work Commission looked upon with favour the fact that Ms Chandler had made an alternative proposal that she work out of the Barrel corporate office, and it noted that the people within her team worked in 3 locations, and the Fair Work Commission found that there was no evidence that working from home impacted upon the way she performed her role. There were 3 problems with what Westpac did once it received the request for flexible work arrangements. 1, it didn't respond within 21 days, which is the first requirement in dealing with a written request for flexible work arrangements. The second thing it didn't do was genuinely consult with Ms Chandler in relation to her request. And the third thing is that when it refused on reasonable business grounds, it didn't adequately set out the reasons upon which that refusal was made. And I believe a critical issue for Westpac was that it misconceived that it could simply point to its hybrid working policy and have reliance upon that the Fair Work Commission would find in its favour. In the decision, there are some fairly important lessons for employers. 1, when receiving an application for flexible work requests, it's important to consult what the National Employment Standards say. There is a requirement to respond within 21 days. There is also the requirement to genuinely consult with the person about their request. And then, if refusing the request on reasonable business grounds, setting out precisely what those business grounds are in a way that shows that you've consulted, genuinely taken an interest in what the applicant has said in relation to their requirements and the flexible work arrangements that they would like, and why that does not suit the way that the work is performed. We're often asked if this decision changes the way that flexible work requests operate and whether this is a landmark decision. I don't personally believe that the decision changes the way that the Fair Work Commission deals with these requests. It simply provides an example of how the National Employment Standards operate and when an employer doesn't comply with those obligations. If anything within the decision or in today's video has given you any need for any legal advice, please do contact us at Citation Group, and we'd be more than happy to assist.